And so, good morning. All right, so we are going to go on the record in the matter of Portfolio Recovery Associates versus Angelique Bates. 163949. And counsel, your appearance, please.
Yeah, good morning, Your Honor. Michael Kirschen here for the plaintiff, P75722. How are you today?
Good, thank you. And Ms. Bates, your name, please.
Angelique Banks.
All right, can you please adjust your camera so that I'm looking at you and not the roof of your car, please?
Oh, sorry.
Thank you. Thank you.
What is
All
his
right.
name? I'm writing down the terms.
Okay, just one moment. Just a moment. Please don't interrupt the court, okay? And so today is the day that we had adjourned this matter to. And just so you're aware, ma'am, the spelling of his name is on his screen.
Is on what? I'm sorry, I don't know what you're saying. Where?
The spelling of the attorney's name is on his Zoom screen.
I don't see it on here.
Okay, well, ma'am, are you on your phone?
Yes.
Okay, so then you have to adjust your view, gallery view or slide left or right. I think left, you have to slide.
Okay. I see it now.
Okay. So today is the date, the adjourned date. The parties were here on February 24th. And counsel, Ms. Banks had sent you, I'm presuming, copies of the bank statements, correct?
Correct, Your Honor.
Regarding the deposits.
Yep.
And where they come from and whatnot.
Correct, Your Honor. Honestly, Your Honor, I had a chance to review them, and I think this is actually pretty simple. The only account that was garnished was the savings account. She has provided nothing showing the funds going into the savings account, and her name is the only name on the savings account, not the other person's name is the payee. So I'm pretty sure that we are entitled to these funds.
Okay, Ms. Banks, I'm going to have you please raise your right hand. Do you solemnly swear from the testimony about to give this man be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, all right, and so I will indicate that I received, or the court received a typed letter this morning. I don't know when you sent it, but it was printed up and received this morning. And so counsel, I don't know if you've received this as well, but what I'll read it into the record. Dear Judge DeSanto, I'm writing in regards to today's hearing case 16-3949, objection to garnishment, and then in all caps it says exempt, and motion of dismissal, and then in all caps it says as well as disputing due. This is, again, in all caps, not my debt, which I stated from the beginning. I'm asking for this to be removed, dismissed, and my funds be returned back to my account. Thank you, Angelique Bates. That is what this communication reads. Did you receive a copy of that, counsel?
No, Your Honor.
Okay. So when the parties were last here on February 24th, the court will note that Ms. Banks indicated she had moved to Indiana on May 1st of 2017. If I recall correctly, this action was filed at the end of 2016 prior to Ms. Banks moving and relocating out of state. The court will also note that there was an order for alternate service that was entered on January 31st, as well as a motion to extend the summons in time for service. In February and March is when it shows that service was effectuated, the default was filed in April, and all that was in 2017. The court will also note that on February 24th and 23, that Ms. Banks indicated she wanted to file a motion to dismiss. And so, Ms. Banks, did you file that motion?
Yes.
When did you file that motion?
I filed it the same day or the next day. I sent it to Carly.
Okay, so did you use a form for the motion,
Yes.
or did you type it up on your own?
The form.
What type of form did you use? Do you recall?
Motion for dismissal. Carly received it and she sent it, put it in the file. I have her email stating that.
Okay, and so did you send a copy to Mr. Kirschenheiter?
Who?
The attorney for the plaintiff? Did you send a copy of the motion to him?
No, I wasn't told to send it to him. I'm not a lawyer, so I don't know about sending things. I sent it to Carly and she said it would be put in my file. When we had this on February 24th, I was told to fill it out and submit it to you, the judge. No one told me to send a copy to the attorney.
And
I asked Carly.
The court cannot give legal advice, neither can its employees. So when you are choosing to represent yourself, you need to familiarize yourself with the process or seek legal representation to assist you with that process. But I'm fairly certain, fairly certain that on that same date, I indicated that anything you file with the court, you also need to send to the attorney.
Oh, no, I didn't hear that part. Because I asked Carly when I sent her the motion, anything I send to her, I always ask her, is there anything else that I need to send? So I didn't know to send that to him. If I hadn't, I mean, it's no secret. If I had known, I would have sent it to him. Not like something I'm trying to hide. Do you see the paper in your file?
Excuse me, there's a motion or an email from Ms. Schmidtke, Carly, on Monday, February 27th, indicating that you need to get in touch with the plaintiff's attorney as well.
I don't see that. Where is that at? I'm looking at the emails right now. Scan document. Motion to dismissal was submitted February 27th. Let me open this up.
At 8:39
Hi,
a.m.
Carly. Okay, I said, hi, Carly. Need to know if this is.
Oh, it's the one from Carly to you.
I'm looking. I don't.
And then, ma'am, you're asking my clerk if she's erasing the emails that she sends to you. Because
Yes, all of
somehow
her.
You're claiming that, please don't interrupt, because you're claiming that they were erased from you, from your phone.
Yes, they were. Someone hacked into my phone during this. After we
And
had the hearing.
you think my court staff hacked into your phone to erase the emails that we sent to you?
No, I was asking her. I didn't see any of the messages from her. They had disappeared from my phone, so that was very odd. Everything I sent her was here, but the email she sent me was not there. So that was very odd that that occurred like that. So I didn't know what had happened to them.
Odd things happen often, but to suggest that a court staff member somehow hacked into your phone and erased emails is not quite appropriate.
No, I was asking her, did she erase them? That's a question. So she could be made aware that my emails had disappeared from my phone. Somebody may have hacked into your court, or it may have just been coincidental, but awareness is key. So I was making her aware that I didn't have it because I needed a copy of that hearing from the 24th for my own records in case I had to get an attorney. And I was never asked if I wanted to get representation. No one ever asked me that.
Ma'am, you have the right to have legal representation, but because this is a civil matter, the court does not, at its own expense, appoint an attorney to represent you. So you certainly have the right to have, you certainly have the right to have legal representation. You can contact a legal aid assistance. You can contact any attorney that you would like.
Okay. So did you ever find the motion for dismissal?
I see here a picture of just a dismissal. That
No,
what you filed, ma'am, what you filed, it says what you filed was something that would have been submitted by the plaintiff, not from the defendant. It says here, notice of dismissal by plaintiff, and it's form MC09. And you've listed your name as the plaintiff, portfolio recovery as the defendant. Then you indicated that plaintiff/attorney for plaintiff filed this notice of dismissal of this case without prejudice. And then you have it dated February 26th. Then you indicate the stipulation to dismiss, to remove and dismiss due to statute limitations has passed ×2, and then you signed it. That's not a motion to dismiss.
Well, shouldn't your clerk have told me that that's not the right form?
Ma'am, I've already indicated that the court nor its staff can give legal advice. And my court staff has to accept the pleadings as they're filed. They are not allowed to tell you if you filed the wrong thing or not. That would be akin to giving legal advice.
I'm
sorry, I couldn't hear you, ma'am.
That's the form that came up when I typed in motion to dismissal. That's the form that came up on your website, Michigan. What is it called? Michigan. I don't remember the website, okay, so but that's the form that came up.
That would be the State Court Administrative Office website that you can obtain forms from. So, but again, that was not the proper form. There's not a motion to dismiss that's been filed, because a motion on a civil matter has an accompanying motion filing fee. You can certainly request that be waived, but that would have to be approved by the judge. I have not received a request to waive any filing fees, nor do I have any receipt showing that you did pay a filing fee for a motion.
I have it in writing. So you're telling me because it's in writing, it doesn't count either? A motion for dismissal?
You have what in writing, ma'am?
Regarding the motion for dismissal.
If you're referencing this form that you filled out, this is not a proper motion form. This is not a motion.
No, it's in writing on there and in other information in my file that I emailed to Carly, that I was requesting a motion for dismissal due to the fact that this debt is past the statute of limitation. And I've always disputed it from the beginning. Portfolio is aware of that.
Yeah. This court has not received a written motion to dismiss along with an accompanying filing fee, or in lieu of a filing fee, a request for a waiver of the filing fee. That is what I'm indicating. You can put anything you want into an email. That doesn't make it a motion. That is why on February 24th, I strongly recommended and suggested that you speak to an attorney.
I don't recall you mentioning that. Carly mentioned it, that you can get an attorney. Every time I ask questions, she said I can get an attorney. But I don't recall you mentioning you need to get an attorney to handle the rest of this case. If I hadn't known that, I would have had an attorney. and I'm
And
not
I
there in
didn't say you
Michigan.
had to. I did say you had to. I said you should. But do you recall me asking you to adjust the camera so I'm not looking at the top of your car?
Okay,
Thank you.
I have the emails up, so I didn't see the camera. I'm reading my emails for this case to see what everything that she had received. Okay, so
And
can you give me the motion for dismissal? Can you give me that number again? Because I don't have that in this notes here.
I didn't provide a form number for the motion for dismissal. I referenced the document that you submitted to the court that says dismissal, form number, it's form NC09.
Okay,
I didn't indicate that that was the motion for dismissal.
all right. Yeah.
And ma'am, when a motion is filed, it needs to be followed up and accompanied with specific facts and legal basis, none of which the court has received.
You said it should be facts.
No, I said it should contain facts as well as a legal basis to grant your motion. That is what I indicated.
The facts are this so-called debt that they have is from 2008, correct?
Mr. Kirchenreiter?
The last payment on the account was in 2013, Your Honor. As far as statute of limitations, even though there is already a judgment, technically, if there wasn't, we could file suit for another 3 months.
Did you hear that, ma'am? Did you understand that?
2013, that's 10 years ago.
I
don't have,
misspoke, Your Honor.
I'm
misspoke.
sorry, I don't have record of that either, because it's not my account.
I apologize, Your Honor. I actually misspoke. I was using the judgment expiration rather than the actual statute of limitations. But as I indicated, there is a judgment already on the account. So
Okay, so ma'am, because there was a judgment on the account and there was a payment that was received, I'm not really sure if you're seeking a motion to dismiss or motion to set aside, there is a statute of limitations as to when that can be brought. So you really need to speak with an attorney. As to how to best go about that. Ms. Banks?
Yes, I'm writing it down. I hear you.
Okay, and so the documentation that you submitted, the bank statement that you submitted to, excuse me, to Mr. Kirchenreiter, this seems to be, okay, so there's a Chase Bank account that says Ashley Battle by Angelique Banks, representative payee. That's on the Chase Bank account.
Yes.
yes, Judge. And to that point, what I was trying to point out to the court is that account was not garnished based on the disclosure. The only account that was garnished was the savings account that only has defendant's name. So don't think we need to get into the legal aspect of whether or not the funds in those accounts are exempt or not. The only account that was garnished was a savings account that has only defendant's name, and she didn't provide it. What she provided had no deposits on it in that account. There was a couple of withdrawals.
Okay. And that's, let me see, so this is the Chase account that so the one that was not garnished.
Yeah, pursuant to the disclosure. Sorry, Judge. Sorry.
Go ahead.
Pursuant to the disclosure, the account that was garnished ends in 7626, and that is the savings account of defendant.
Would you agree with that, Ms. Banks?
No, I disagree. I showed Suzanne, this guy here, I never met him. The other guy I think was Arabic, Suzanne Bardo. I have the emails where I sent him the email of the statement showing that the exempt funds were transferred, which you should have a copy also, Judge.
Okay.
So no, I
When you say that
disagree.
the exempt fund, I'm sorry, just one moment. When you say the exempt funds are transferred, you're indicating that the exempt funds that are in 2181 are transferred to 7626?
Yes, you should see that in the file. Do you have those papers in front of you showing the transfers? Carly asked for that information and I sent it to her from that account.
I see that. Counsel, I presume you have that as well?
Your Honor, all I have is the documentation that was sent to my office. Obviously, I know it can be difficult when we're not actually in court. I'm not exactly sure what she's referencing. However, I would indicate if she's saying there were funds transferred into her own, solely her savings account, I'm not exactly sure how those would be exempt.
And so, ma'am, how would those funds be exempt if they're transferred into a bank account in only your name?
Because those are all Medicaid waiver funds and mixed in with SSI. Do you see the information I sent you regarding where the funds are coming from and how I'm paid? How those are to cover for taking care of my daughter and providing for her? I sent that as well. One company is Together Home Care, which is a Medicaid PA provider. And then the other one is In-Care Solutions, which is the Medicaid waiver. And I sent that all to you.
Oh, I'm looking at that, and that's all done on the 2181 account. So I guess I'm unsure as to why you're transferring into your own personal account.
That's a savings account. I'm her mother, so I am her rep payee. So if I want to move the funds over, that's what I did. I did it. It is still exempt funds. All of that income is stated there that was made from Medicaid, that was paid to take care of Ashley Battle, my daughter, was transferred over. I only did that because I needed to have that money separated for account information, so I can make sure I kept the money balanced out, which.
Your Honor,
So I mean, that's neither here nor there really, because the point is the funds are exempt. And
Your
it
Honor,
is showing you exactly where it's coming from and where the money came from, and that it was. I have no other income that's coming in. I don't know if that's what you're questioning, or I mean, I don't understand the question, but it's very direct.
Your Honor, 2 points. First of all, I don't even believe defendant has proven that the funds are exempt, but I'm pretty sure she's not provided any law that shows that she can take exempt funds for her daughter and place them in her own private account that is only for her. The only funds that were withheld by the bank were funds only in the defendant's name.
Okay, so ma'am, you've indicated that you don't work, correct?
Right.
That you're not employed at all.
Right. Everything I get is help providing, take care of my daughter. I'm not able to work because of my daughter's disability.
Okay, so then please explain why Together Home Care dated February 24th of 2023 indicates to whom it may concern. Angelique Banks was hired as a home health aide on March 30th, 2022, when was assigned to work an ongoing Medicaid PA funded case for Ashley Battle. On January 1, 2023, Together Home Care transitioned to using ADP as a third-party payroll vendor. All payroll documents prior to the current year were provided by Paychex Oasis and were labeled as such. Please feel free to contact the office with any questions regarding Angelique's employment with Together Home Care of Indianapolis. Then, there's an email dated February 15th of 2023 from Sandra Maldonado, the president owner of In-Care Solutions. This email is to confirm that Angelique Banks is an independent contractor in In-Care Solutions. The payments that we make to her are considered difficulty of care payments, as described in IRS Notice 2014-7. The funding source for these payments is Medicaid. In-Care Solutions is an agency approved by the state of Indiana to provide home and community-based services to individuals on Medicaid waivers. If you have any questions, please let me know. Thank you, Sandra Maldonado. So, ma'am, you're receiving payments of employment, of income. You're receiving income.
Exactly. See, income to take care of Ashley Battle. You see her name up there?
Ma'am, you testified to this court. You've been sworn in to tell the truth. You testified to this court that you're not employed. Well, you're in fact employed by In-Care Solutions as well as Together at Home. Well, Together Home Care. So you are employed.
These funds are exempt. I work for my daughter. I don't have a job where a regular job. I work for my daughter. These funds are to help take care of her since she is staying in the home. I'm not sure what part, I'm not understanding your question. It's Medicaid waiver funding. I've been taking care of my daughter for 31 years, which is very rare and not seen. Most people put their children, adults in group homes. I refuse to do that. I'm giving her the care that she needs. So this is what they do to help parents do that, to provide a better quality of life for my daughter. So this is a mess, and it's not looking good on you guys' end, because it's like you're not understanding, trying to act like you're not understanding what I'm saying. Yeah, they reference it as to employee, but it's used to help provide for the adult. I'm calling it child because my baby's still my baby, but.
Ma'am, I am understanding perfectly. You have a disabled child that requires care. You've indicated via testimony under oath, as well as emails or paperwork or letters that you're sending into the court, that you are not employed.
I'm not employed. I don't know regular job.
Ma'am, the letters that you provided to the court dated in February of 2023 would suggest that you are employed. You receive paychecks from 2 companies. Now, if your daughter is receiving Medicaid payments as well, that would be a good thing to know. Is she also receiving that?
I don't understand your question.
Does your daughter receive disability benefits from the government?
SSI, yes. You have that letter, right?
Okay. And so how much does she receive for SSI?
I believe it's $914.
Okay. So your daughter receives SSI payments. And so that is deposited into the 2181 account, correct?
Yes.
Your paychecks from Together Home Care and In-Care are also deposited into that 2181 account, correct?
Yes,
Okay. And then you transfer money into your own account. That's the 7626 account, correct?
that wasn't my own account. That's me and my daughter's account. My name is only on there because I opened it online, and I didn't know I had to add my name. I didn't know I had to add her name. I'm sorry. At the time when I did it online. I'm sure you're aware you can open up accounts online, and I thought they were considered linked accounts. I just got that account, and like I had it for years. I just had got it when I opened it in 22, I believe, or the end of 21. I would have to look back at the records, but yeah, I just had got that account. So
Okay, so you had that account for some time.
yeah, I opened it thinking that it was still under both of our names. Wasn't aware that I had to actually have her name put on there, or if it really mattered at that time. But
Okay,
the money
well,
again was transferred from the 2181 account. It was transferred from that account, which is SSI funds, the waiver, and the Medicaid.
and your paychecks. If you're talking, I can't hear you. You muted yourself. Okay, so and your paychecks are also deposited, correct?
I'm sorry.
And okay, you keep muting yourself. Your paychecks are also deposited. Ms. Banks? Ms. Banks? Ms.
Can you hear
Banks,
me?
can you hear me? Yes. So your paychecks are also deposited into the account, and then you transfer it into your own account, correct?
Hello?
Would that be correct, ma'am? Ms. Banks?
Hello?
Yes, Ms. Banks, can you hear me?
Just only talking. I don't hear anything.
Okay, well, Ms. Banks, the court can hear you. Can you hear me? Ms. Banks?
I can't hear you. 1 second. Can't hear anything. Hello?
Yes, can you hear me now? Can you hear me now, Ms. Banks? Ms. Banks, can you hear me?
Can you hear me?
Yes, can you hear me? Can you hear me? Ms. Banks?
Hello?
Hello? Can you hear me,
Hello?
Ms. Banks? Yes, can you hear me?
They're proceeding. I can't hear anything.
Can you think, Terry, can you,
Hello?
hello, can you hear me?
Me?
Can you hear me?
Hello?
Hello, can you hear me?
Yeah, I'm not sure why I went out, but sorry.
Can you hear me?
Yes.
You can hear me now.
Yes.
Okay. All right. So the last question I asked was that your paychecks also get deposited into that account, correct?
Yes. Mm-hmm.
Okay. And so then you transfer them into an account that's in only your name. I heard what you said, that you didn't know that it wasn't connected to your daughter's account or what have you. However, it has been, you had that account for over 1 year, and you would have known or noticed that only your name appears on that account as opposed to the 2181 that's your daughter's account that also has your name on it as payee. So this would suggest that this is your personal account. When you transfer money into this account that's in only your name, you do not have any disability funds of your own that are deposited into this account. You don't have any disability funds. I mean, when you're transferring it over to this account, you're opening it up. So the court has heard that you've indicated that this should be dismissed, that you don't owe the money, that it's past the statute of limitations. However, the court gave you 3 weeks to file a motion appropriately or to contact legal representation. And based upon the law, there are not any valid objections that have been filed with the court. the objection to garnishment is not the appropriate venue to raise the issue of dismissal or the issue of the validity of the judgment. And so for those reasons, the court is denying the objections to garnishment, as the objections are invalid. Garnishee shall immediately release withheld funds to the plaintiff attorney. And ma'am, if there's something that you can submit to Mr. Kirschenheiter that would support your claim that the funds are exempt, that are in your personal account, that are in there from your paycheck, then perhaps that may be revisited. But it's important to note that the account that your name is on, that your daughter's disability payments are deposited into, is not the account that's being garnished. Anything else, counsel?
It looks like you filled out an order, Judge.
I am filling out, yes, I filled out the order.
Thanks, Judge.
Anything else, Ms. Bates?
I'm sorry.
Anything else?
I disagree to all of this. I submitted all the information that was necessary and you all are ignoring it.
Yeah.
As far as,
Ma'am, let me just clarify. You can certainly disagree with that. If you'd like to file an appeal, you can certainly file that appeal. You are mistaken when you state that the court has chosen to ignore all of it, because the court reviewed all of it and went into great detail on the record as to why it denied your objection. You are certainly entitled to your opinion, but the court did not ignore the documents that you filed.
Thanks, Judge.
All right, ma'am, if you'd like to file an appeal, I would strongly suggest you contact an attorney, because the staff here at the court cannot give you legal advice as to how to proceed with your next steps.
I need copies of all of this. What you said, I need copies of everything that you just said that took place today. Why you're denying it, I need copies of all of that sent to me.
Well, then what you'll have to do is you'll have to email in to request a copy of the transcript. That's what you'll have to do.
Email who?
You'll have to email into the 27th District Court to request a copy of the transcript.
Anyone in particular?
No, ma'am, just a general email, and it will get to the appropriate person.
And just put the case number on there, correct?
Yes, you should also put your name on there as well.
Okay.
Have a great day, Judge.
Thank you.
Happy St. Patty's Day.
You as well.
Idiots. Okay.